We've gone through this rapid response issue thoroughly. I have some questions, and I may ask them for the record with regard to that. But I would like to focus instead on this alliance business and the FMC response to it. It seems to me that what's happened here is there's been a very significant change in the nature of the industry since the last amendment to the Ocean Shipping Act, and that the FMC's authority and responsibilities no longer fit the reality of the industry. The emergence of all of the alliances and the significant power they have as a result of those alliances raises a question of antitrust, anti-competitive activity. I noticed, Mr. Butler, I was reading your testimony here, and you kindly gave us the specific sections of the alliance agreements, and you helpfully underlined those sections or those particular sentences that are to your benefit. For example, the parties shall negotiate independently, and the next 50 words are underlined, independently with stevedores, tug operators, and so on and so forth. And then there's this word provided. However, that specifically gives the alliances the opportunity to share information that is necessary to collude. And I'm going, something's wrong here, because the specific, provided, however, the parties are authorized to discuss, exchange information, coordinate negotiations with the providers of services. Bottom line on all of this is the law is not up to date with the realities of the industry as it exists today. Our task is to address changes in the law as well as implementation of the law. It seems to me that the FMC can correctly argue that they're simply carrying out the law. We can debate whether that is or is not the case and whether they're carrying it out correctly. But I think there is no doubt in my mind that the current law is out of date and has to be changed. So my specific questions go to that task that we have of writing law. I want to start with Mr. Allegretti. How would you change the law to address the concerns that you have so ardently expressed to this committee?
The problem, Mr. Garamendi, with the current interpretation of the law is the Shipping Act has an explicit and express prohibition against foreign ocean carriers negotiating collectively with domestic service providers, except that it does exactly what you just said. And then it says, except or provided that it doesn't otherwise violate the antitrust laws. The problem with that in the real world is who's going to determine that these negotiations have violated the antitrust laws? Is the tugboat operator supposed to sue his customers under the antitrust laws to push back on this? Shall we rely on the Department of Justice to do it? Should we rely on the FMC to do it? These are not going to happen in the real world, and the result is that, in fact, the express prohibition in the law will be routinely violated in the marketplace.
So what change?
Then the change would be to take that provision out of the current statute that says, provided that it doesn't otherwise violate the antitrust laws.
Okay. So the removal of a specific section of law.
It is a phrase at the end of that section that has the express prohibition in it.
Mr. Corey, same question.
Congressman, I would have to take some time with our general counsel and with my fellow commissioners. I can't individually speak on behalf of the FMC. I don't have a formed opinion as to whether that would be a bad idea or not. I don't have a current opposition to considering it, but I would want to have a reasoned amount of input from all parties to see might there be some unintended consequences with that. But I can't say, as I sit here and give testimony today, Congressman, that I am opposed to that as a solution. So, you know, it's not that any of us, and I said this, you know, when we had a private meeting the other day at the commission, you know, the only degree I have on my wall is my United States Merchant Marine Officer's license as a master and first class pilot.
I appreciate that.
And we have others, so, you know, we have the sympathy.
Well,
but as you say, we have to work with the law.
Excuse me for interrupting, but I would like your opinion, I'd like the opinion of the commission as to how to address this problem of competition or lack thereof. So if you could respond to that question.
We will promptly prepare answers to all
We
of
are
the committee.
probably less than a month away of writing the new law for the Coast Guard Maritime. And so I would appreciate that in the next 2 weeks, if you would please provide that. Mr. Butler, the same question to you.
Mr. Garamendi, obviously, if the Congress wishes to amend the law, would be pleased to work with you in looking at language. That's the prerogative of the Congress to make that policy and make the law. I would offer the perspective that the existing Shipping Act, as it was amended in 1998, did contemplate the kinds of activities that are going on today. I'm not so sure that we're in a position where we need to look at a major rewrite of the Shipping Act. I think there's enough authority and flexibility to deal with these issues. I would just note that the issue Mr. Allegretti has raised is very specific, and I understand you to be talking about perhaps broader issues. I think it's important to make that distinction.
Well, let me be very specific. Mr. Allegretti has proposed a specific change in the law, that a certain clause be eliminated. I assume you have not had the opportunity to opine on that, but take a run at it.
Well, I want to talk to Mr. Allegretti about what he's trying to accomplish, and we have had a conversation, and as I understand it, and he'll set me right if I get this wrong, I think what he's trying to have is a flat prohibition on joint negotiation for tug services.
Mr. Allegretti?
Can I try to put a more specific and practical perspective on what the problem is? There's a lot of conversation about law and analysis and competition. But here is the effect of what will happen if we don't change the law. And let me give you a practical example. You're a tugboat operator in a port somewhere in the United States. You have 3 major customers, and they each constitute, let's say, 25% of the business that you have in that port. Those 3 customers form an alliance, and they are given authorization by the FMC to come to you and jointly negotiate their rate. The first thing they do is they share the rate information, and they determine that one of them was paying $1,000, one was paying $1,500, one was paying $2,000. Well, the immediate thing they'll ask that tugboat operator for is give us all of the work at $1,000. Once they've done that, perhaps they'll say, and you know what, this is 75% of the business, maybe you ought to give it to us at $800. So if you're the tugboat operator and you're faced with this dilemma, you are now faced with either taking work at a non-compensatory rate that doesn't allow you to meet the cost of capital for your $15 million tug, for the crew that you provide family wages to, or the loss of 75% of the business that you enjoy in this port. We should not allow that to happen, Mr. Garamendi.
I very much appreciate your argument. It's clear to me, and I think to many members of this committee, that we have a situation evolving in which oligopoly power is in existence and can be used to the detriment of competition, pricing, and a competitive environment. It seems to me that we need to modify the law, which is now almost 30 years old, so that we recognize the realities of the industry as it exists today. I'm particularly troubled by the language in the alliance, as Mr. Butler has presented to the committee, that allows the alliances to provide amongst themselves all the information they need to collude, independently, but nonetheless collude, prior to independent negotiations. I think that's wrong. I think we need to change the law. Mr. Allegretti, you've made a specific proposal as to how that might be done. I intend to pursue that. We will be writing a new authorization for the Coast Guard Maritime in the next month or so, and it would be my intent to try to address this issue by changing the law to require competition, or to set up a balance that would create competition and eliminate collusion. Now, that would be my intent, and I would appreciate, Mr. Corey, if you and the FMC commissioners would opine on that, and specifically on the language that Mr. Allegretti has proposed. Mr. Butler, if you would do the same, it would be very helpful. I yield back my time.
Thank the ranking member. So let me just go through this really quick. There's three issues here.